Hello and welcome back to the Law with Charlie YouTube channel. I'm Charlie Medcalf, the host and leader of this channel. So it's great to have you back. Firstly, you will notice if you are watching this in real time that I'm not going in order with these lectures, and that's fine. That's just going to be the case here. If you do want lectures which are in a more ordered fashion and lectures which go into much more depth, then I would strongly encourage you to check out some of my premium content. There's more details about that at the end of this lecture, and then if you also comment in the comment section, I will get back to you. And so in this mini lecture, we are essentially looking at a new topic in the law of evidence, and that is the topic of illegally and improperly obtained evidence. And this is very much an introduction to this topic, so we will be talking about what actually is illegal and improperly obtained evidence, and we will have a brief overview of what we will be covering in this topic. This obviously makes more sense if you've already done the rest of the evidence course, but with these free versions of my content, this is mainly for revision rather than covering something for the first time, although I do imagine this can be used in a number of different ways. But let's now go on to look at our learning objectives for this lecture. So, there's three main learning objectives here, and so to start with, you should be able to describe the prima facie rule as to the admissibility of illegally and improperly obtained evidence. Then you should be able to explain the confession exception, and then also explain the torture exception. So there's one general prima facie rule as to admissibility, then two exceptions, which will be the contents of this lecture, and then in the next lecture we will be starting to look at ways of excluding illegal and improperly obtained evidence. That's a bit of a handful. So what actually is illegally and improperly obtained evidence before we get on to the principle of admissibility? Well, it's essentially evidence which has been obtained outside the rules of evidence. So it could be evidence which has been collected outside the law of evidence. So, for instance, it could be a breach of code C of pace in terms of police interviewing, or it could be a breach of code, I think it's E or F, for not following the correct procedures for identification evidence. And there's all sorts of other examples as well. So could be a breach of the law. So for instance, if someone's tapping your phones without the relevant permission, as I say, the PACE guidelines, particularly when it comes to confessions, even inducing individuals into committing crimes can be seen as illegal or improperly obtained evidence, depending on the circumstances though, and that very much falls under the rule of entrapment, which we will be looking at later in this series on this topic. There's also police trickery, which in some cases can be lawful and properly obtained, and in other cases it can be illegal and improperly obtained. But essentially, to summarise this in one sentence, what is illegal and improperly obtained evidence? It's essentially anything which is capable of bringing the criminal justice system into disrepute. The criminal justice system is in an interesting position because they've got people's lives, people's liberty at their hands, and they are having to do a lot. On the one hand, they're having to give justice to the victims as far as they're able to and uphold the rules and laws of the land, but on the other hand, they also need to make sure the defendant gets a fair trial. And if a defendant has been unfairly taken to court and then unfairly convicted, based on the authorities not collecting the evidence and not following the rules which are in place to ensure the defendant has a fair trial, then that could bring the criminal justice system into disrepute. For instance, some of the things which instantly come to my mind are the post office scandal, and there's obviously much less oversight in that case, largely because of the private prosecutions, but that saw innocent individuals being convicted for fraud, I believe it was. There's also various other issues such as the Birmingham 6 and so on and so forth. So that's the basic idea of what illegal and improperly obtained evidence actually is. Anything which could bring the criminal justice system into disrepute. And at least for our number one way of excluding such evidence in particular, but also throughout this topic, you'll see that idea of bringing the criminal justice system into disrepute is kind of a fundamental principle in this topic on the law of evidence syllabus. So, what is the principle of admissibility? Well, it's actually just the same as it is for any other evidence, and that is that all evidence is prima facie admissible if it is relevant. So you will see from the very start of this series of lectures that any evidence which is relevant can be admitted to either prove a fact and issue or one of the other various components of fact and issue, collateral fact, and so on. And this is seen very much in Attorney General's reference number 3 of 1999, which essentially summarised the law and how prima facie evidence which is admissible is relevant. And this was also seen in the Crown and Leatham in 1861, where the judge in that case essentially said it doesn't matter how evidence is obtained, whether it's obtained illegally or in any other way, as long as such evidence is relevant to the case, then that evidence may be admitted as evidence. And this is very much still the position in the law of England and Wales during the present day, although there are measures in place to try and ensure that such evidence is not used in an unfair manner. And as such, there are two exceptions to this general rule of admissibility, and they are as follows. The two main exceptions to the prima facie rule that any relevant evidence is admissible is confession evidence, and particularly confessions which have been obtained by oppression or other behaviour which could render the confession unreliable, and also evidence which has been obtained as a result of torture. And we will be able to go into a little bit more detail in terms of these exceptions in just a moment. However, in such cases, evidence will not be admissible even if relevant. So, for torture in particular, it could be really relevant. It could prove that the defendant committed the crime and could put them in prison because it would eradicate any doubt the finder of fact may have. However, in this situation, that evidence will be inadmissible even if it is relevant. And so these are some two really important two important exceptions. And as you may know from earlier in the course, when it comes to confession evidence, there is slightly more flexibility, but we will see that throughout both this lecture and also in the lectures to follow on this topic of illegally and improperly obtained evidence. And so now let's go into a bit more detail in terms of confession evidence as the first exception to the prima facie rule that all evidence which is relevant is admissible. So, confessions, as I have said, which look to have been obtained as a result of oppression or other behaviour that is capable of rendering a confession unreliable is inadmissible, and this is very much seen in section 76, subsection 2 of the Police and Criminal Evidence Act, and such evidence here is inadmissible as a matter of law. We will look a bit later in this series at different reasons why evidence may be excluded, reliability for instance, or could punishment, and there's other such approaches as well. However, the main thing here is if a confession could undermine the reliability of the trial, that would undermine the fairness of the trial, and so it should not be admitted. And so if you are interested in this area, I would strongly recommend you go and look at the Police and Criminal Evidence Act, PACE as it is often abbreviated to, and look at the provisions in a bit more detail. And so the second exception when it comes to the exceptions against the prima facie rule of admissibility in terms of evidence obtained by illegal or improper means is the evidence obtained by torture. And the rule here is really quite simple and quite straightforward. Evidence obtained by torture will not be admissible, and I suppose that's particularly if it is a third party, but essentially it doesn't matter. Evidence obtained by torture of a third party or anyone else will not be admissible. That's because of how we have the human rights legislation, particularly the European Convention of Human Rights in England and Wales, and that puts on a complete ban on torture because it's seen as being a form of dehumanising behaviour. And this exception was very much considered in the case of A and the Secretary of State for the Home Department, number 2 in 2006, so feel free to go and have a look at that case in your own time. But this is mainly relevant where international countries are involved. So that's because not all countries have the same standards of human rights or morals as we do in England and Wales, and so it's mainly, this exception is mainly relevant in that situation. However, let's go into a bit more detail on this exception. When will the torture exception actually apply? So this exception will usually apply where someone who is not on trial is tortured, where someone who was tortured by security services in another overseas country, and places where there is less respect for human rights. And if they are having a trial in England and Wales, the courts are obviously bound by the European Convention on Human Rights, and there's Article 6, right to a fair trial, and so it would be questionable if some of the evidence was obtained as a matter of torture. That, I would argue, could lead to a breach of Article 6, the right to a fair trial, as well as just being highly against the human rights legislation, which would be highly problematic in any scenario. And so essentially the torture exception will apply when someone who is not on trial is tortured, someone was tortured by security services in another overseas jurisdiction, and in places where there is less respect for human rights. Now, there are no loopholes for evidence obtained by torture. However, although there's no loopholes for torture, there are for confessions, which we'll see later on, and this is found in section 76, subsection 4 of PACE. But essentially that section explains how if evidence is discovered as a result of information provided in an excluded confession, then that evidence may be relied upon at trial, providing that the trial fact, so the jury in this case, are not made aware that this evidence was found as a result of an illegally or improperly obtained confession. So that's a bit of a loophole to get evidence in which has been found by unfavourable means, shall we say. However, when it comes to torture, this does not apply. Torture, it's an outright ban, and there's no way to get evidence, and even if it is relevant, there's no way to get such evidence into trials where there's torture involved. So that very much concludes this lecture on the introduction to illegally and improperly obtained evidence, and so now you should be able to describe the prima facie rule as to the admissibility of illegally and improperly obtained evidence. So namely that prima facie, if evidence is relevant, it is admissible. Explain the confession exception with reference to case law, and you should also be able to explain the torture exception and the various details in relation to that. And so this is very much an introduction looking at what illegally and improperly obtained evidence is, and two of the main grounds of when such evidence can be excluded, the exceptions to the general prima facie rule. And so in the next lecture we'll be starting to look at different ways of excluding such evidence, and this includes judicial stays as well as a judge's discretion, and later on we will be looking at the unique situation in terms of entrapment as well. So before I finish, if you do have any questions or anything at all, please do let me know in the comments section below. Please like, comment and subscribe. By liking, you're going to be showing the YouTube algorithm that this is good content and will help others in a similar situation to you and me to find this content to really help them with their studies. Please do comment, even if it's just to say hello, because I love engaging with my audience and I always strive to try and respond to every single person who does leave a comment. And subscribe. Again, this shows me that this content is needed and wanted, and it motivates me to keep producing this content, but also it means that you will never miss any of my content in the future. Also, do check out my podcast if you haven't done so already. You will find it on Spotify and anywhere where you listen to your podcasts. Just put in the name of my brand, Law with Charlie, and it should come up. And if you haven't done so already, do look into getting access to my premium content. This is just a free basic version of my premium content, but my premium content very much goes into significantly more detail. There's extra content as well, there's critical analysis included and so on. So if you're looking at getting higher grades and you find this kind of revision substance to be useful, then the premium content is for you, and I would very much recommend that you go and look at that content. Finally, support me. What I'm doing here isn't always easy, and by supporting me it will help me achieve a number of my goals. So firstly, by supporting me, you will help me be able to continue to provide free legal content and free public legal education on my channel and podcast, which I believe is very important. It will also help me develop my research and academic skills through my future PhD, which will then allow me to properly provide even more knowledge over the law and my areas of expertise, which would be really useful for anyone who, particularly those who want to practice law as a solicitor and barrister and really want to be the best they can be. My research, well, my intended research would really help with that. And also by supporting me, once I'm qualified as a barrister, that will allow me to provide more pro bono support, because I am a strong believer that pro bono is very, very important, and the more support I get from here, if you're willing and able, the more pro bono support I am able to offer as a result. And so there's links on how you can support me below in the descriptions. But thank you for watching this. I hope you have enjoyed it. Again, like, comment and subscribe, and I look forward very much to seeing you in my next video. Goodbye.